It's no secret that as of January 1st, Walt Disney's very first depiction of Mickey Mouse, known as Steamboat Willie, has entered the public domain. This essentially means that the copyright once held by Disney has officially expired. But what does this mean for Etsy sellers and small creative businesses who want to profit from the depiction of Disney's most iconic character? Unfortunately, misunderstanding the laws regarding Mickey can land you in a bit of a legal mousetrap. In case you're new here, my name is Starla Moore, founder of the Handmade Alpha Academy for Etsy sellers and manager at erank.com, Etsy's most popular SEO tool. And over the years, I've created several videos about copyright and trademark infringement on Etsy, especially when it comes to Disney. You can find those videos in this playlist up here. But now, with the world's most famous mouse entering the public domain, I'm seeing a slew of misleading headlines that are contributing to the overall confusion about what is now legal versus what could potentially land you in a big fat lawsuit. Let's start with the most common misconception, which is that Mickey Mouse is now in the public domain. This is 100% false, despite what popular news sites are saying in their headlines. The traditional version of Mickey that we know and love is still highly protected by Disney, and will be for the foreseeable future. In fact, in past cases, Disney has taken legal action against businesses who use depiction of their intellectual property. This includes threatening a daycare with legal action back in 1989 for painting a mural of Disney characters on their walls, as well as a more recent case back in 2022 when Disney sued a couple for selling assorted Mickey ears and other Disney-themed products. If you want to read the official court document, I'll go ahead and link a PDF down below because it includes all of the products that this couple was selling. At this time, there's no set price for an official license to sell Disney-themed items, as this is decided on a case-by-case basis. But most retailers who have obtained a license report paying an annual licensing fee that starts at a minimum of $10,000, plus a percentage per product sold of up to 50% of the cost. Now, you may be saying, yeah, Starla, I've heard all of this before, but if Disney cares so much, why do so many people get away with selling these products on Etsy? And why isn't Etsy doing anything about it? It's important to note that on Etsy, only the owner of a copyright can report infringement of said copyright. Etsy does not own Disney, which means that in order to legally remove these items from the platform under infringement of intellectual property, Disney has to report them. And they do. And while it may not seem like anything is being done, shops get shut down all the time for copyright infringement on Etsy. In fact, it's one of the most common questions that I see in my own inbox from sellers who have had their shop shut down. And as much as I wish that I could help them, you cannot get your shop back or even a buyer account back if you get caught for copyright infringement on Etsy. Not to mention, Disney isn't blind to this issue. In fact, they have a team of lawyers dedicated to watching businesses who violate their IP. And just like the couple that we talked about earlier, often Disney legal teams will sit and watch these businesses over time, taking action once they've noticed that the seller is making a lot of money from their IP. So no, Mickey Mouse is not in the public domain, or at least not the version that you and I know and love. Only the very first fossil of Mickey, set in black and white, with no gloves, and with solid black pupilless eyes, are included in this release for the public domain. For example, if you were to take a still frame from the original Steamboat Willie animation and place it on a shirt, this would technically be okay under the public domain. However, when it comes to listing your new Steamboat Willie products, there's a whole other layer of complexity. For starters, even if you're using the correct version of Steamboat Willie, in this case we'll use our shirt example, you cannot call it a Mickey shirt or a Disney shirt, nor can you use the names Mickey, Mickey Mouse, or Disney in your listings. This includes your titles, tags, and descriptions. But what about the use of the name Steamboat Willie specifically? In a recent statement to the Associated Press, Disney stated that, "We will of course continue to protect our rights in the more modern versions of Mickey Mouse, and other works that remain subject to copyright. In cases like these, it's important to know the difference between trademark and copyright. When Steamboat Willie entered the public domain, this essentially means that the image of this specific character is no longer under the protection of Disney's copyright. However, a trademark is separate from copyright and has no expiration. Copyright defines artistic, literary, or intellectual created works, such as novels, music, movies, software code, photographs, and paintings that are original and exist in a tangible medium, such as paper, canvas, film, or digital format. But the use of the words Steamboat Willie is currently up for debate. In fact, a quick look in the US trademark database shows a pending trademark of the words Steamboat Willie in the use of children's toys by LA Star Capital Group, Inc. as of July of 2023. And while we can only speculate right now as to whether this trademark will be approved, it just goes to show how the current Steamboat Willie terrain is feeling a bit more like the wild, wild west each day. As of right now, there is no genuine legal clarification on what is and is not allowed when it comes to the use of the name Steamboat Willie, though this hasn't stopped satirical film companies from sweeping in. After the 2023 release of Winnie the Pooh into the public domain, a horror adaptation of Disney's beloved Yellow Bear was released in record time. Similarly, another horror film based on Dr. Seuss's The Grinch also recently released, despite the Seuss family still holding strict copyright over the character. However, due to loopholes and parody laws, creators of the film were able to navigate this legal gray area, primarily due to the fact that they never used the word Grinch in the film or marketing. A risky leap, but one that I'm positive that they worked alongside legal guidance to accomplish. Right after the release of Steamboat Willie's copyright on January 1st, two separate horror studios announced film adaptations featuring Disney's iconic character. As of right now, Disney is not responding to questions from reporters regarding these two films, which leads everyone to wonder if they will attempt to find legal loopholes of their own in order to take action against these films. So, what's the final verdict on Steamboat Willie for product creation? The short answer is, we don't know, and we likely won't know until Disney begins taking legal action against those who cross what is currently still a very gray line, thus setting clearer boundaries through the trial and error of those attempting to profit from this character. My advice, especially for those selling on platforms like Etsy, is to be careful. I personally wouldn't rush to add a bunch of Steamboat Willie items to my own shop, at least until a few months have passed and we get a clearer idea of what is acceptable and not acceptable. Because despite the fact that Steamboat Willie is in the public domain, Disney still utilizes this character within their own trademarks, such as the Disney Animation Studios logo, which was most recently updated in 2022. As of right now, this trademark states that the mark consists of a motion mark of an animator's drawing visually flipping one after another and transitioning into an animated clip of a mouse character tapping his foot and whistling while holding a ship's wheel, followed by the appearance of the wording Walt Disney Animation Studios underneath the animated mouse character, which sounds an awful lot like the image that we were just told on January 1st would enter the public domain. Again, gray areas. Over the next few months, it's very likely that Disney's lawyers will be on the lookout for items that blatantly cross this line in the sand, as they've done in the past. Which is why, if you currently sell Disney-themed items, I highly recommend stopping as soon as possible, no matter where you sell. It's never been legal to sell these items, but the attention now focused around Mickey and Steamboat Willie is akin to Sauron's eye skimming the landscape in search of Frodo in the ring. And trust me, Disney's eye is not one that you'll want to have focus on you when it comes to the defense of their intellectual property. As I always say, unless your lawyers can beat Disney's lawyers, it's probably best to lay low for a while until we have more definitive guidelines, which will likely come in the form of future Disney lawsuits against infringing brands. I don't know about you, but I'd personally rather stay safe than sorry. Regardless of what I think or what the future holds for Disney's most iconic mouse, on paper, Steamboat Willie entered the public domain on January 1st. LA copyright and trademark law specialist Aaron J. Moss stated that the question is where Disney tries to draw that line on enforcement, and if courts get involved to draw that line judicially, which essentially means only time will tell. Let me know in the comments what you think about the release of Steamboat Willie. I'll personally be keeping a close eye on the legal battlegrounds to come, so expect more videos about this topic in the future. In the meantime, stay safe, stay informed, and obviously, Cue the funky lo-fi beat. And if courts get involved to draw that line judicially,